Welcome everyone to our channel. We are back again with another exciting quiz from Section 5, Real Estate Brokerage Activities and Procedures. Without wasting any time, let's jump right into the question. Okay, the first question for today is: which of the following statements is true regarding a sales associate's changing employers? Option A, the former employer must notify the FREC within 30 days of the associate's termination. B, unless the former employer's license has been suspended, the associate's license remains in force during the change of employer. C, the associate must notify the FREC on a prescribed form within 5 days of termination. D, the associate may not remove any records from the former employer's office. Alright, now I am going to give you some time to think about the option, then you can come back with the answer. I hope you had enough time to think about the option. So the correct answer for this one is going to be D, the associate may not remove any records from the former employer's office. A license shall cease to be in force whenever a broker changes her or his business address. A real estate school operating under a permit issued pursuant to Section 475.451 changes its business address, or a sales associate working for a broker or an instructor working for a real estate school changes employer. The licensee shall notify the Commission of the change no later than 10 days after the change, on a form provided by the Commission. Alright, second question. Regarding escrow accounts, which of the following is true? Option A. Sales associates must deposit funds into the account the same day they are received. B. A broker may designate a sales associate to be signatory on all accounts. C. The broker has a lien on all escrow deposits. D. The broker has 30 days to correct any account errors. Think about the option wisely and come back with an answer. I hope you have your answers ready. So the correct answer for this question is going to be D. The broker has 30 days to correct any account errors. A broker shall be provided a reasonable amount of time to correct escrow errors if there is no shortage of funds and such errors pose no significant threat to economically harm the public. For purposes of this subsection, reasonable amount of time shall be defined as 30 days from the date the last reconciliation statement was performed or should have been performed. Alright, next one. Violators of Florida antitrust laws can be sued for recovery of: Option A. 3 times the amount of the damage. B. A maximum of $5,000. C. A minimum of $10,000. D. The exact amount of damage. So think that one over. Alright. The answer for this one is going to be Option A, 3 times the amount of the damage. Any person who shall be injured in her or his business or property by reason of any violation of S. 542.18 or S. 542.19 may sue therefore in the circuit courts of this state and shall recover threefold the damages by her or him sustained, and the cost of suit, including a reasonable attorney's fee. Alright, next one. Question number 4. If there is a dispute involving the amount of the broker's commission, what may the broker do regarding the trust funds in the associated escrow account? Option A. Disperse the commission payment to him/herself. B. Retain the commission amount in the account until the dispute is resolved. C. Move the commission amount to another escrow account until the dispute is resolved. D. Nothing. The funds do not belong to the broker. You know the drill, think that one over and come with an answer. Alright. The broker should retain the commission amount in the account until the dispute is resolved. In case of a dispute as to the amount of the commission, or the time of payment, the broker may retain only the amount of the claim in said account and in trust, until the dispute is settled by agreement, arbitration, mediation or court proceedings, as provided in Section 475.25, 1d, Florida statutes. Let's move on to the next question. And the question is, which of the following information is not required as part of the minimum information to be included in an escrow account statement reconciliation? Here are the options for you. Option A. Reconciliation date. B. Names of depositors. C. Outstanding checks. D. Name of bank. Take your time, think that one over and come up with an answer. So the correct answer for this one is going to be D. Names of depositors. The minimum information to be included in the monthly statement reconciliation shall be the date the reconciliation was undertaken, the date used to reconcile the balances, the name of the banks, the names of the accounts, the account numbers, the account balances and dates, deposits in transit, outstanding checks identified by date and check number, an itemized list of the broker's trust liability, and any other items necessary to reconcile the bank account balances with the balance per the broker's checkbooks and other trust account books and records disclosing the date of receipt and the source of the funds. Next one. If a rental information list is provided for a fee, the tenant may be fully reimbursed for the fee unless Option A. The list was inaccurate. B. The tenant failed to attain the rental. C. The list contained material misrepresentations. D. The tenant demanded the refund after 60 days of paying the fee. Think that one over and come up with an answer. I hope you had enough time to think about the answer. So if a rental information list is provided for a fee, the tenant may be fully reimbursed for the fee unless the tenant demanded the refund after 60 days of paying the fee. So yes, the correct answer is option D. A demand from the prospective tenant for the return of the fee, or any part thereof, shall be made within 30 days following the day on which the real estate broker or sales associate has contracted to perform services to the prospective tenant. Next one. If a broker conducts business at a location other than the principal brokerage office, what is the broker required to do? Option A. Include the address of the second location on all advertising for the principal brokerage. B. Register the second location as a branch office. C. Actively work from both offices. D. Staff both offices with sales associates and unlicensed assistants. Okay, take some time and think that one over. Okay, what is the answer for this question? Well, it is going to be option B. Register the second location as a branch office. Whenever any licensee desires to conduct business at some other location, either in the same or a different municipality or county than that in which she or he is licensed, such other place of business shall be registered as a branch office, and an annual registration fee prescribed by the Commission, in an amount not exceeding $50, shall be paid for each such office. Now the next question is. A sales associate may collect the commission directly from the seller only when. Option A. He or she has performed real estate services for the seller. B. His or her employer consents. C. He or she has sued the seller. D. He or she collects the commission in his or her own name. Take your time to think that one over. So the correct answer is going to be option B. His or her employer consents. Sales associates may only collect commissions in the name of the employer and with the consent of the employer and may only perform real estate services on behalf of employer. Sales associates may not sue the principal to obtain the commission. The question is, where may trust funds not be deposited? Option A. Credit union. B. Broker's business account. C. Savings and loan, or D. Title company with trust powers. Take some time and think that one over. Alright. What is the correct answer for this question? Well, the trust funds may not be deposited to broker's business account. So yes, the correct answer is not option A, C, or D. But it is going to be option B, broker's business account. Trust or escrow account means an account in a bank or trust company, title company having trust powers, credit union, or a savings and loan association within the state of Florida. Okay, this question is going to be the last one for this video. So the question is, Florida allows brokers to deposit personal funds into a sales escrow account. What is the allowed limit of personal funds? Option A, $500. B, $1,000. C, $1,500. D, $5,000. Okay, think about the option and come up with the answer for this question. I hope you had enough time to think about the answer. So let's find out what the correct answer is going to be. Well, the correct answer is B, $1,000. A broker may place and maintain up to $1,000 of personal or brokerage funds per each sales escrow account. Well, this is it for today's video. We did only 10 questions, however, we have many interesting questions and reading materials for you guys. For that, please visit our website dolphinschoolofrealestate.com, where you can enroll in our courses and get access to tons of questions. Anyways, if you liked today's video, then please don't forget to like, share, comment, and subscribe to our channel. And we will be back with the next video.